Shanu Fug Usra. This is United Nuwaubian Nation of Moors, coming to you live today on what's today? It's the 21st of December 2018 on the Gregorian calendar. We just wanted to bring forth a pretty important issue regarding Dr. Malachi Z. York and his ECOWAS case. If you guys aren't familiar with ECOWAS, that stands for the Economic Community of West African States. And, Dr. York has been saying that he's a diplomat of Liberia, which is on the west coast of Africa. And so a lot of these inter-country, especially if it's an international case like this one, the ECOWAS court has jurisdiction over a lot of over about 8 or 9 countries in Western Africa. So I guess through some alliances and through some cooperation that they decided and agreed upon establishing this tribunal, which is in Nigeria. As you can see here, looks like Wuse II, Abuja, Nigeria. And that looks like it's a Garki, Abuja. That's the city, I guess that's the state within the country of Nigeria. I'm not gonna sit here and pretend like I know Nigerian areas at the back of my hand, because I don't. So this is some of the case law that I was able to obtain off the net. I think this is pretty much public, information. Let's see. I think here's the ECOWAS website if you guys wanted more information about how everything works. Looks like they got stuff for the youth, education, health, which are vital to any society. And then I want to read an article about the Liberian diplomat, which is Dr. Malachi Z. York, and how he's being denied health care. And his attorney, if you guys are familiar with this at all, about Dr. York, United Nuwaubian Nation of Moors, and where everything is at in this current state. So anyway, let's jump right into this. I guess this is called the Community Court of Justice. It's a tribunal. Looks like something that's in some kind of, looks like a European language right there. Tribunal de Justicia da Comunidade. Probably like French or something. Okay, but this case law was recorded on the 18th day of April 2016 between Dr. Malachi Z. York, plaintiff, and the Republic of Liberia, which is a defendant. So that's already, that's not a very good sign that the nation that's supposed to grant Dr. Malachi Z. York his diplomatic status is defending against Dr. Malachi Z. York. So that's not a good look right there. And it says before their lordships, I'm trying to pronounce these names as best as I can. One, the Honorable Justice Fredai Chijioke Nuwoke. Second Lordship, Honorable Justice Hameye Foune Mahalmadane. And 3 is the Honorable Justice Ali Oune Sal. And the registrar, assisted by Obu Bakar Jibo Diakite Esquire. All right. Representation of the parties. 1, Frederick A. B. Jawe. Counsel with Layla R. Holden, agent to the plaintiff. Christina Ta, Council, Ministry of Justice, Republic of Liberia. All right. Delivers the following judgment. 1. Summary of the facts and procedure. The plaintiff alleges that the defendant appointed him as her consul general to the United States in 1999. He was accredited to the office near Atlanta in Georgia, United States of America. According to him, on May 8, 2002, he was arrested on an indictment for sexually related offenses purportedly committed prior to his appointment, and was tried and sentenced to 135 years by a court in the United States. He further complained that the defendant, whom he represents as Consul General, neither intervened, protested, nor offered him diplomatic protection by invoking diplomatic immunity on his behalf and securing his release after conviction. He therefore claimed that such omission or negligence by the defendant amounted to the violation of his human rights as provided by the African Charter on Human and People's Rights in the Vienna Convention on Diplomatic Relations, 1961. He therefore claimed for a declaration that his rights have been violated by the defendant, and also claimed damages. So basically, Dr. Malachi Z. York and his attorneys are saying that since he was a diplomat of the Republic of Liberia, when he got sentenced, they didn't do anything to intervene on his behalf to protect his rights. And so now he's bringing this case. He's actually suing them in court. So that's, the judge is just kind of summarizing what is the plaintiff's charges against the country Republic of Liberia. So 2, the plaintiff's case. By an application dated the 10th of July 2014 and lodged before this court on the 18th of July 2014, the plaintiff, a naturalized citizen of the Republic of Liberia, the defendant, alleged that his right as provided for by the African Charter on Human and People's Rights and the Vienna Convention on Diplomatic Relations has been violated by the defendant. In his narration of facts, he alleged 1. that the defendant is a signatory of the revised treaty establishing the Economic Community of West African States, ECOWAS, 1993. 2. That he is a citizen, consul general, and diplomat of the defendant appointed on the 15th of December, 1999 by President Charles Taylor, the then president of the defendant, and accredited near Atlanta, Georgia, United States of America. He further avers that, consistent with his appointment with diplomatic status, he immediately took up his assignment near Atlanta, Georgia, United States, and conducted his duties and responsibilities until he was violently arrested by the United States authorities on the 8th of May, 2002. The plaintiff further states that his diplomatic passport bearing numbers 003828 was renewed by the government of the defendant on 7th June 2006 without reservation by the government of President Ellen Johnson Sirleaf, the current government of Liberia. 4. He further contained that to confirm or reconfirm his community citizenship and diplomatic status as Consul General of Liberia, he filed a petition for declaratory judgment before the 6th Judicial Circuit Civil Law Court, Liberia, and he obtained a judgment in his favor in 2004. A judgment that further declared that he is a citizen of the defendant Liberia and her Consul General. The plaintiff also avers that in spite of the fact that both the United States and the Republic of Liberia are signatories to the Vienna Convention on Consular Relations. He was arrested on 8th of May 2002 by the government of the United States, tried and imprisoned for 135 years without the government of the defendant doing anything concrete to secure his release and repatriation back to Liberia as required by diplomatic intercourse. 6. He further stated that his arrest, trial, and imprisonment for 135 years at USP Florence ADMX, located in Colorado, United States, runs contrary to ECOWAS Convention on Diplomatic Privileges, Immunities, and Vienna Convention on Consular Relations, as well as the United Nations Covenant on Civil and Political Rights and the Constitution of Liberia. 7. The plaintiff avers that all governments of the defendants, including the government of President Ellen Johnson Sirleaf, are fully aware and placed on judicial notice that the plaintiff is a citizen of Liberia and Consul General of Liberia. In spite of this, administration after administration of the Republic of Liberia has only simply acknowledged the foregoing facts, but has totally and absolutely done nothing to secure his release and repatriation back to Liberia. 8. According to him, he avers that the states and member countries of the Economic Community of West African States, ECOWAS, have jurisdiction over their nationals, and in particular consul general and diplomats accredited and assigned to foreign countries to protect their rights and immunity from arbitrary arrest and imprisonment by their receiving states. Since the government of Liberia has done nothing to protect his rights, he brings this complaint. 9. The plaintiff further avers that the privileges and immunities of diplomatic agent exempt him from the jurisdiction of the receiving states. Thus, the plaintiff prays the ECOWAS Community Court of Justice to take judicial notice of the foregoing provision of the Vienna Convention on Consular Relations cited supra, and forthwith proceed to order the government of Liberia to secure his release and repatriation back to Liberia consistent with the diplomatic requirements and intercourse. The plaintiff consequently sought the following orders from the court. A declaration. A. That he is a citizen of Liberia and Consul General of Liberia, and as such, the government of Liberia is morally and legally obliged to secure his release from the USP Florence ADMX Federal Penitentiary in Colorado, United States, and accordingly ensure his repatriation back to Liberia, consistent with the Vienna Convention on Consular Relations of 1963 and 1964, to which Liberia and United States are parties. That being Consul General of Liberia, Liberia is obligated to secure the applicant's release in line with the Vienna Convention on Consular Relations of 1961 and 1964. C. That his arrest, trial, and conviction on 8th May 2002 and subsequent imprisonment for 135 years at Florence ADMX, Colorado by the United States without Liberia securing his release and repatriation is inconsistent with the 1961, 1963, and 1964 Conventions on Consular Relations, and thus violates the applicant's human rights. D. That the defendant is legally obliged to respect and uphold the rights of all of its heads of mission and representative, including Dr. Malachi Z. York, applicant, Liberia's Consul General and diplomat, consistent with the Vienna Convention on Consular Relations. E. That the applicant is exempt from arrest and imprisonment by the United States, and because Liberia is a party to the African Charter on Human and People's Rights, your lordships need to declare that Liberia seeks and secures the release of the applicant. F. That Liberia's failure and refusal to secure the release and repatriation of the applicant back to Liberia, his sending state and country of origin, violates his human rights, and runs contrary to the Vienna Convention on Consular Relations and the African Charter on Human and People's Rights. Applicant prays that the defendant be ordered to ensure his release and repatriation back to Liberia, and the sum of 10 million Nigerian naira, or equivalent of 60,000 US dollars as damages from the defendant. Alright, there was a lot said there, but basically he wants the judge or the judges to grant him repatriation back to Liberia, and he wants money for damages. So this is the Republic of Liberia's case, or this is their argument. So let's go through this. 3. The defendant's case. The defendant, in answer to the plaintiff's claims, denied liability for all the claims and urged the court to dismiss same. In further answer, the defendant stated as follows. 1. That the claims of the plaintiffs have no legal basis, as it is tended to mislead the court into believing that the plaintiff is entitled to rights and privileges accruing to diplomatic agents and consular officers. Furthermore, that with appointment of the plaintiff as Consul General to Atlanta, Georgia, he did not attain the status of diplomatic agent under the Vienna Conventions on Consular Relations 1963, as there was no evidence that he was carrying out his duties as such consul as at then or until he was arrested by the United States authorities. Furthermore, there is no evidence that he was issued an exquisitor. Now, that's a word I had to look up, because I had no idea what that means. I know it's a legal word that needed to be looked up. So let's look at that word. Exquisitor. An official recognition by a government of a consul, agent, or other representative of a foreign state, authorizing them to exercise the duties of office. So this is just a recognition of someone operating from a foreign state as a consul general, and Liberia would have to recognize that and let Dr. York operate as consul general or as a diplomat. So let's read on. That the plaintiff surreptitiously and fraudulently obtained Liberian diplomatic passport number 003828 out of his prison cell, as there was no evidence of issue of such passport by the Ministry of Foreign Affairs of the defendant. She further posited that the passport was not renewed by the government of Liberia under Ellen Johnson Sirleaf as claimed by the defendant. 3. That with regard to the claim by the defendant that the 6th Judicial Court, Civil Law Court, Montserrado County, which declared that the plaintiff as Consul General was entitled to immunity and therefore should be repatriated by the defendant, that the said judgment lacks foundation, judging from the provisions of the Vienna Convention on Consular Relations and other national instruments upon which the court relied. 4. That as to the plaintiff's allegations that the defendant is a signatory to the Vienna Convention on Consular Relations, the defendant concedes to the fact, but argues that, consistent with Articles 41.2, 2 and 3, 42 and 43 of said convention, consular officials are not immune from criminal proceedings except with respect to acts performed in exercise of their consular functions. That, as a matter of law, only diplomatic agents enjoy immunity from criminal jurisdiction of the receiving state under Article 31.1 of the Vienna Convention on Diplomatic Relations 1961. That the relevant law is Article 41.1, 2, and 3 of the Vienna Convention on Consular Relations, which provides as follows. Okay. A. Consular officials shall not be liable to arrest or detention pending trial except in case of a grave crime and pursuant to a decision by the competent judicial authority, except in case specified in paragraph 1 of this article. Consular officials shall not be committed to prison or liable to any other form of restriction on their personal freedom save in execution of a judicial decision of final effect. If criminal proceedings are instituted against a consular official, he must appear before the competent authorities. Nevertheless, the proceedings shall be conducted with the respect due to him by reason of his official position, and except in the case prescribed in paragraph 1 of this article, in manner which will not hamper the exercise of consular functions as little as possible. D. When in the circumstances mentioned in paragraph 1 of this article, it has become necessary to detain a consular officer, the proceedings against him shall be instituted with minimum delay. E. Similarly, Article 42, in the event of the arrest or detention of consular staff, or if criminal proceedings is being instituted against him, the receiving state shall promptly notify the head of the consular post, should the matter be himself the object of any such measure. The receiving state shall notify the sending state through diplomatic channels. F. The defendant therefore argued that consular officers are not immune from criminal prosecution for acts or conducts perpetrated by them not in the exercise of their consular functions. In the instant case, the plaintiff was prosecuted and convicted on account of sexually related offenses which have nothing to do or have absolutely no bearing or relation to the exercise of his consular relations. The defendant further contended that G. They have no legal obligation to secure the release of the plaintiff since he was convicted of a crime unrelated to the exercise of his functions as a consular official. The fact that the past government of the defendant exhibited benevolence in seeking the release of the plaintiff as evidenced by the plaintiff's own admission shown by the verbal note attached to his application places no duty on the government as a matter of law to secure the plaintiff's release. On the issue of the plaintiff's entitlement to diplomatic protection, the defendant states that while it has duty to protect its diplomatic agents, it is obliged to do so if the conduct or the action for which the officer or agent is held to answer was done in the exercise of his or her official function. In the instant case, the plaintiff has not shown that he was arbitrarily arrested, nor did he plead that he was deprived his right to due process. The plaintiff rather recognized that he was arrested, tried, and convicted. The defendant contends that the plaintiff, not being a diplomatic agent of the defendant at the time of his arrest and not being arrested on account of actions or conduct carried out in the exercise of his official duty, is not entitled to immunity from criminal jurisdiction of the United States of America. I. The defendant also contends that ECOWAS Convention on Privileges and Immunities is only applicable to ECOWAS member states. The issue of the plaintiff incarceration in the United States, the subject matter of this proceedings, is known between the government of the defendant and government of the United States, which is not a member of ECOWAS. J. That the plaintiff's counsel in the statement of facts only intended to mislead the court. According to the defendant, plaintiff's plaintiff's plea in law, specifically on page 6 of the plaintiff's application, recites, quotes, Article 31(1) of the Vienna Convention on Diplomatic Relations, but cites the same as Vienna Convention on Consular Relations, being fully aware that the provision of the law grants immunity to diplomatic agents and not consular officers. That's a pretty big claim that the defendant's making. K. Furthermore, the defendant also contended that Articles 2, 3, 4, 5, 6, 7 of the African Charter on Human and People's Rights relied on by the plaintiff are not supportive of the plaintiff's theory and the facts and circumstances of this case. In conclusion, the defendant contended that based on the facts and circumstances of the case, the plaintiff was not arbitrarily arrested, deprived his right to personal liberty. Neither was he deprived of his freedom except for reasons and conditions previously laid down by law. The plaintiff was tried according to the law and afforded due process. Hence, the provisions of the African Charter on Human and People's Rights relied upon by the plaintiff are not supportive of his case, and urged the court to 1. Deny and dismiss the application as same is legally wanting. 2. Declare that Article 31 of the Vienna Convention on Diplomatic Relations is not applicable to consular officers. 3. Declare that the defendant is not legally obligated to secure the release of the applicant plaintiff. 4. Analysis of the issues for determination and legal arguments of the parties. As stated earlier, the plaintiff's case is that he was appointed the Consul General of the Republic of Liberia. The defendant, on 15th of December 1999, he was accredited at Atlanta, Georgia of the United States. He was issued with diplomatic passport. It looked like, did the number change? It looks like the number kind of changed from before. Number D/P03828-0408. See attachments A and B of plaintiff's claim. On the 8th of May 2002, the plaintiff was arrested, indicted, tried, convicted, and sentenced to 135 years imprisonment. He argued that his arrest, trial, and imprisonment while he was Consul General of the defendant is a violation of his human rights. In the same vein, the hands-off approach adopted by the defendant, especially their failure to diplomatically secure his release, violates his human rights under the Vienna Convention on Consular Relations and the defendant's Constitution. He therefore argued that the defendant is both morally and legally obligated to seek his release and repatriation back to Liberia. By an application dated the 10th of July 2014, he filed on 18th of July 2014. The plaintiff sought the following reliefs from the court, namely, a declaration. 1. That the plaintiff is a citizen of the defendant and its consul general. The defendant is morally and legally obligated to secure his release from the United States and repatriate him back to Liberia in consonance with the Vienna Convention on Consular Relations. 2. That states have jurisdiction over their nationals, even when they are outside their borders. Accordingly, being the Consul General of the defendant is obliged to secure the release of the applicant in line with the Vienna Convention on Consular Relations of 1961 and 1964. 3. That the arrest, trial, and conviction of the applicant and subsequent imprisonment for 135 years on the 8th of May 2002 by the Court of the United States without Liberia securing his release and repatriation is inconsistent with the 1961, 63, and 64 conventions on consular relations and thus violates the applicant's human rights. 4. That the defendant is legally obligated to respect and uphold the rights of all its heads of mission and representatives, including the applicant, consul general, and diplomat, consistent with the Vienna Convention on Consular Relations. 5. That consistent with Article 6A to G of the ECOWAS Convention on Privileges and Immunities, the applicant as consul general and diplomat of the defendant is exempt from arrest and imprisonment by the United States. And because the defendant is a party of the African Charter on Human and People's Rights, thus the court should declare that the defendant should seek and secure the release of the applicant. 6. That the failure and refusal of the defendant to secure the release and repatriation of the applicant back to the territory of the defendant, his sending state and state of origin, violates his human rights and runs contrary to the Vienna Convention on Consular Relations and African Charter on Human and People's Rights. And 7. That the defendant should pay the sum of 10 million Nigerian naira, or equivalent of United States dollars 60,000, as cost damages against the defendant. At the expiration of time required for the defendant to file a reply, and following the failure of the defendant to enter appearance and file a reply, the applicant has brought 2 applications, namely: A. Application of the expedited hearing in which he sought for an order of this court granting the plaintiff expedited hearing of the suit pursuant to Article 59(1) and 2 of the rules of this court. B. An application asking the court to enter judgment in default against the defendant for failure to enter appearance or file a defense in the suit in accordance with Article 90 of the rules of this court. However, before the hearing of the 2 applications, the defendant filed an application pursuant to Article 35(2) of the rules of this court seeking for the order of the court granting an extension of time within which the defendant should enter appearance, file, and serve a defense on the plaintiff, and to deem same as properly filed and served. C. On the 12th of February 2015, the defendant moved its motion for extension of time. The plaintiff, who had originally filed a motion to strike out the application for extension of time, decided to withdraw same. So I guess what's happening here? So what's happening is the defendant, meaning the Republic of Liberia, filed for an extension of time, and then the plaintiff, which is Dr. Malachi Z. York and his attorneys, filed to strike the application, meaning pretty much we don't want to agree to that. We don't want to agree to an extension of time for the defendant to file his paperwork. And then they decided to, it says right here, extension of time, decided to withdraw same. The motion for extension of time was granted by the court, and thus issues were joined between the parties. So for some reason, the strategy for the attorneys of Dr. York was to strike for the extension of time, probably to expedite the hearing. That's the only logical reason I can see to put a motion to strike him. Following this development, the plaintiff withdrew his applications for expedited hearing and default judgment, and both were struck out on the 12th February 2015. In her statement of defense, the defendant denied all the claims of the plaintiff. Specifically, the defendant argued that the entire application should be dismissed for lacking any legal basis and intended to mislead the court into believing that the immunities and privileges accruing to diplomatic agents and consular officers are the same. 2, that the plaintiff is not a diplomatic agent of the defendant, and that the purported Liberian diplomatic passport N003828 exhibited by the plaintiff was fraudulently obtained out of his prison cell, since there was no record at the Ministry of Foreign Affairs of the defendant relating to the said passport. Although, hold on, y'all. although in the plaintiff's narration of facts he claimed that the 6th Judicial Civil Law Court, Montserrado County of the defendant declared that the plaintiff as a consular general and thus enjoys diplomatic immunity and should be repatriated by the defendant. The said judgment lacks foundation, having regard to the provisions of the Vienna Convention on the Consular Relation and other international instruments relied on by the court. 4. Consular officers are not immune from criminal proceedings except with respect to acts performed in the exercise of their functions, but that the plaintiff was arrested, tried, and convicted of grave crimes of sexual assault related to his functions as a consular officer. That the defendant has no legal obligation to secure the release of the plaintiff having been convicted of a crime unrelated to the exercise of his functions as a consular officer. The mere fact that the past government of the defendant exhibited benevolence in seeking the release of the plaintiff as evidenced by the admission of the plaintiff himself shown by the note verbal attached to his application, Exhibit P/6, places no obligation on the current government of the defendant as a matter of law to secure the release of the plaintiff. 6. That while the defendant has a duty to protect its consular and diplomatic agents, this obligation only extends to cases where the agent is held to answer for acts done in the exercise of his or her official function. This does not apply to the plaintiff. 7. That the ECOWAS Convention on Privileges and Immunities, which the plaintiff relies on, is only applicable to member states of ECOWAS. The issue of the plaintiff's incarceration, the subject matter of the current proceedings, is an issue between the defendant and the government of the United States, which is not a member of ECOWAS. 8. That none of the action or inaction of the defendant has violated the plaintiff's rights. That Articles 2, 3, 4, 5, 6, and 7 of the African Charter on Human and People's Rights relied upon by the plaintiff does not support his case. The defendant therefore urged the court to dismiss the case of the plaintiff. 5. Analysis of the case of the parties. At the end of pleadings, the court asked the parties to address it on the import of Article 88 of the rules of this court on the propriety of this case. The parties comply with the request. However, the court opines that the case can be decided fairly and fully without recourse to the submission of the parties. So, I think at the last sentence there, when it talks about that the case can be decided fairly and fully without recourse to the submission of the parties, I don't think they needed any further information to come to a determination. So, I mean, right now it's not looking very good for Dr. Malachi Z. York, by the way that the Republic of Liberia is framing the case, but it's all up to the judge to either agree with the defendant or agree with the plaintiff, which is Dr. Malachi Z. York, so he can go back to Liberia. So, 6. Issues for determination. From the pleadings and arguments in law, 4 major issues can be discerned as the basis of the action, and if appropriately addressed, the court will holistically determine the merits or otherwise of the case. However, it is necessary to mention that the existence or otherwise of a cause of action for which the court can resolve the dispute between the parties is the claim of the plaintiff. From the pleadings of the plaintiff, it is apparent that the claim is grounded on the status of the plaintiff first as an ordinary citizen of the defendant, and thus of the economic community of West African states, of which the defendant is a member, and then on his purported position as consul of Liberia in the United States, which the circumstances culminating in this action arose. 1. Accordingly, the following issues call for determination. 1. Whether the plaintiff, as a citizen of the defendant and mutatis mutandi of ECOWAS, is entitled to the diplomatic protection from the defendant. Now hold up. Let's look up this word right quick, y'all. Let's just look up mutatis mutandi, which is obviously Latin. Let's just look this up and see what Google can tell us real quick. All right, it's an adverb. So, and it says used when comparing two or more cases or situations, making necessary alterations while not affecting the main point at issue. Okay, so it pretty much sounds like he's comparing cases in law, and he's making alterations without missing the main point, so the judge can come to a determination on what's the best outcome of this case. All right, so number 2, whether the plaintiff, by virtue of his purported appointment as the Consul General of the Republic of Liberia to the United States of America, is immune from arrest, indictment, prosecution, conviction, and sentenced to terms of imprisonment by the host or receiving state, and whether failure to secure the release of the plaintiff by the defendant violated any of the rights of the plaintiff under the African Charter on Human and People's Rights, particularly Articles 3, 4, 5, and 6. 3. Whether from the totality of the facts presented by the plaintiff, there is an indication of a characteristic violation of human rights of the plaintiff as to give the court competence to entertain the suit, and if the answer is in the positive, whether in the circumstances of the case, this court can grant the relief sought by the applicant. With regard to issue number 1, the plaintiff claims that every citizen is entitled to protection by his state or origin whenever in a foreign state. To buttress his argument, the plaintiff cites 2 major international human rights instruments against the defendant, namely A. the United Nations International Covenant on Civil and Political Rights, and B. the African Charter on Human and People's Rights. In contemporary international law, diplomatic protection consists of the invocation by a state, through diplomatic action or other means of peaceful settlement, the responsibility of another state for an injury caused by an internationally wrongful act of that state to a national or legal person that is the national of the former state, with a view to the implementation of such responsibility. See Article 1 of the International Law Convention, Draft Article on Diplomatic Protection, 2006. Although a state is under duty to protect its nationals and may take up their claims against other states, there is, under international law, however, no obligation for states to provide diplomatic protection for their nationals abroad. See the case of HMHK versus Netherlands, 94 ILR P 342. See Kaunda versus President of South Africa, 2004, 2 ALC 5. The right of diplomatic protection is not a right of the individual, but that of the state. Thus, in Mavromantis Palestine concession case. So it looks like what the court is getting to is saying that even though Dr. Malachi Z. York was a citizen of Liberia, and a state is under a duty to protect its nationals, It's saying nationals, meaning if you were in Nigeria, like, I mean, not Nigeria, I'm sorry, Liberia, under their territorial jurisdiction. But when you're internationally, or you're in another nation, performing activities, whether official or not, then if you're not recognized by that state as a consul or a diplomat, and you're just a regular citizen who's abroad, that the state does not have to intervene on your behalf as a national. And politically, I'll just throw this in, you wouldn't really see another nation protect a national that committed a crime. Now, I remember, I think 1998 or 99, there was a couple of U.S. citizens that went to North Korea and actually vandalized somebody's car. Now, the United States did try to intervene on the citizens' behalf, but I think because of the crime, those two people were stoned in North Korea. So, you know, I mean, there's situations politically where a nation, your sending nation, I guess that's the verbiage that they use here, will protect you. But this is a tricky case, and you know, the government of Liberia chose not to intervene, and the judge is pretty much saying you cannot force the state or the country, Liberia, to intervene on your behalf. So let's keep reading. We're about 3/4 of the way through this. The Permanent Court of International Justice succinctly stated that by taking up the case of one of its subjects and by resorting to diplomatic action or international judicial proceedings on his behalf, a state is in reality asserting its own rights to ensure in the person of its subject respect for the rules of international law. Thus, an individual cannot force his state of nationality to take up a claim for injury done to him against another state. In fact, in Kaunda versus the president of South Africa, Supra, the court rightly stated that diplomatic protection is not recognized in international law as human right, but a prerogative of state to be exercised at its discretion. Prerogative, that's an interesting word, because prerogative means to exercise a right or perform a right. Matter of fact, let's look it up. I could be wrong. So let's look it up. It's important to understand what's happening with the master teacher's case. It's a noun, and one, a right or privilege exclusive to a particular individual or class. So the judge is saying that the right is exclusive to the state, or belonging to the state, and it's exercised at its own discretion, meaning their own will, exercise of will, or their own discretion on their own decision. They can do it if they want, sua sponte. The plaintiff, as earlier noted, referred to the provision of the International Covenant on Civil and Political Rights and the African Charter on Human and People's Rights to buttress the fact that his right has been violated, but none of these texts make provisions for such a right. The right to diplomatic protection is not a human right as the concept is understood, and is not enshrined in any international text on human rights. The court finds that when the plaintiff cites a text, he refers to provisions which deal with legally recognized rights, like freedom from arbitrary arrest, freedom from association, the right to a fair hearing and trial, the right to the security or physical integrity of the person, and not provisions which deal with a right which any individual can claim in order to demand from the state, as of right, that intervene in his favor. Accordingly, the plaintiff's argument on this plank must fail, and the court holds so. That's interesting, because the freedom from arbitrary arrest, freedom from association, the right to a fair hearing and fair trial, the right to the security of physical integrity, and not provisions that deal with a right which an individual can claim. So I guess the court is kind of insinuating that he's making arguments as a diplomat, a consul, and an individual. But when they cite these covenants on civil rights and human rights, those don't pertain to an official operating in official capacity, which they said before is not a human right, and it's at the prerogative of the state to exercise their intervening capabilities through diplomatic channels. So it's like he's trying to claim two things. He's trying to claim an individual or claim official status, in which you cannot claim both. You have to decide which one you're going to claim. And so that's why it failed, which the attorney should have known this before they even filed the case. On issue number 2, it is obvious from the evidence submitted that the plaintiff's case also hinges on the alleged fact that he was a diplomatic agent at all times material to this suit and therefore inviolable. Accordingly, the plaintiff argues that the defendant is legally bound to assert his diplomatic status so that he would not have been tried, convicted, and sentenced to imprisonment by the receiving state, in this case, the United States of America. In claiming immunity, the plaintiff copiously quoted the provision of the Vienna Conventions on Diplomatic Relations 1961. The relevant provision is Article 31.1, which provides a diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving state. However, Article 1 of the same convention is opposite to the determination of the status of the plaintiff. This is because it provides for the category of persons who qualify as diplomatic agent as envisaged by Article 13.1 Supra. It provides the definitions of officers who are diplomatic officers. And I'm going to take a short break. Give me about 2 minutes and I'll be right back to finish this case. All right, I'm back, y'all. Let's continue this very important case. Thus, A, the head of mission is the person charged by the sending state with the duty of acting in that capacity. B, the member of the mission are the head of the mission and members of the staff of the mission. C, the members of staff or staff of the mission are members of the diplomatic staff of the administrative and technical staff of the service staff of the mission. D, the members of the diplomatic staff are members of the staff of the mission having diplomatic rank. E, a diplomatic agent is the head of the mission or member of the diplomatic staff of the mission. F, The members of the administrative and technical staff are the members of the staff of the mission employed in the administrative and technical service of the mission. G. The members of the service staff are members of the staff in the domestic service of the mission. In the same vein, Article 3 on its part stipulates the functions of a diplomatic mission. Thus, 1. The functions of a diplomatic mission consists inter alia in A. Representing the sending state in the receiving state. B. Protecting in the receiving state the interests of the sending state and of its nationals within the limits permitted by international law. C. Negotiating with the government of the receiving state. D. Ascertaining by all lawful means conditions and developments in the receiving state and reporting thereon to the government of the sending state. E. Promoting friendly relations between the sending state and the receiving state and developing their economic, cultural, and scientific relations. However, nothing in the convention shall be presumed as precluding or preventing the performance of consular functions by a diplomatic mission. So he's saying, with all the technical talk on Article 3 of said instrument, international instrument, saying that any of that pertains to a consular. It only pertains to the service of the diplomatic mission, the administrative handling of the diplomatic mission, and then the diplomatic agent himself. Doesn't say anything about a consular. However, nothing in the convention shall be presumed as precluding or preventing the performance of consular functions by a diplomatic mission. It is obvious from the above provisions that diplomatic agents are ambassadors or high commissioners and other diplomatic officers and staff who are appointed by the sending state and deal directly with the receiving or host state. In this case, the applicant claims that he was appointed consul general by the defendant, and by virtue of his position, his arrest, indictment, trial, and conviction by the host state without the defendant intervening on his behalf is contrary to international law. He interchangeably invokes the Vienna Convention on Diplomatic Relations and Conventions on Consular Relations and the Optional Protocols 1963. It is obvious from Article 31.1 of the Vienna Convention on Diplomatic Relations 1961 Supra that a consular general is not one of the recognized persons to be accorded privileges and immunity because he is not a diplomatic agent. The defendant has rightly argued that the plaintiff has surreptitiously presented the matter as if he is a diplomatic agent. The defendant has equally contested the status of the plaintiff as even a consul by maintaining that the plaintiff is not a member of the consular and diplomatic corps of the defendant. Above all, that his diplomatic passport may have been fraudulently obtained. So, yeah, this is not looking good for Dr. Malachi Z. York because he's using too many laws and he's trying to play too many positions to get free. He should have just stuck with one thing. And probably at this point, I would say that Dr. Malachi Z. York probably should have stuck with the fact that he was a citizen of Liberia, because if he's saying he's a diplomat, and you can't be a diplomat and a consul general at the same time, so that's very confusing. The attorney should have been known that the court would probably frown upon such argument, and that the position just wasn't strong, man. It just wasn't strong. So And now they're talking about fraud, and that doesn't look good for the for our for the master teacher, for Dr. Malachi Z. York. So I'm just kind of concerned that that this might not have been the right approach to this case. So hold on for a second. All right, we got an anonymous caller on the line. I could take a second out from reading this ECOWAS case to
Hello?
yeah, and what is your name, ma'am? Okay,
I can't hear you, sir.
Oh, you can't hear me? I'm sorry. Okay, well, I can hear you on the line, but I guess you can't hear me, so
No.
Oh, wait a minute. Can you not hear me still?
You know what? Listen here. You're not going to do this on my line.
Okay, I'm not quite sure what happened there, y'all. I'm not quite sure what happened there, but we're gonna keep this moving. So, all right, I'm gonna start right here. But she probably couldn't hear me, so she thought I was probably playing a crane call or something. Okay, so for the avoidance of doubt, the issue to be clarified is whether the provision of the Vienna Convention on Diplomatic Relations are applicable to consul generals, the consular officers, as to afford them the same immunity as afforded diplomatic agents. In order to clarify the issue, one needs to look at the provisions of the Vienna Conventions on Consular Relations, which deals with specifically with consular generals. Hold on, because I was making some noise in the background. The Vienna Convention grants limited privileges and immunities to consular staff or personnel in receiving state. And now they come back, they're just gonna have to wait, man. They can be arrested and prosecuted for criminal offenses and other offenses, except ones committed in the course of the performance of their duty. Article 41 provides that consular officers may not be arrested or detained except in case of grave crimes and following a decision by a competent judicial authority of the receiving state. If criminal proceedings are instituted against a consul, he must appear before the competent authority. So they're saying this consular, I forgot the title of the instrument, but they pretty much saying that a consular general is not immune from prosecution of a grave crime. That'll probably be like, drug dealing or murders or swindling funds from national banks of the receiving state. Something, grave crime. I guess that's what a grave crime means to me. And since I think the Mann Act was used against Dr. Malachi Z. York, that would be considered a grave crime. So unless unless Dr. Malachi Z. York's attorney is able to convince the ECOWAS court that that's not a grave crime, and then that would bring him out of that statute in that article, because it says may not be arrested or detained except in case of grave crime. So that would have been a good argument to use, but they didn't use that. And the court gonna look up everything. They look up everything, man. They got databases full of case laws, and the judges read a lot. So let's keep going. Under Article 43 of the Convention of Consular Relations, The immunity of consuls, including their consul general, is restricted in both criminal and civil cases to acts done in the official exercise in their consular functions. Right. So they gotta do something in the mission of their duty to be afforded immunity. In Copal versus Copal, Copal and Copal versus the Federal Republic of Nigeria, it was held that the provision of refuge by the Nigerian Consul General to a Nigerian national was an act performed in the exercise of a consular function within the meaning of Article 43 and thus attracted consular immunity. There is no evidence that the offenses for which the plaintiff was convicted were acts done in the performance of his consular duties. Rather, they are grave crimes committed by him for which he was afforded due process. The law also is that consuls must possess a commission from sending state to the authorization exequatur from a receiving state. As rightly posited, there is no evidence that the plaintiff was issued with an exquisitor by the receiving state, and this further shows that his status as consul general of the defendant at the time of incarceration is questionable. In the light of the foregoing, it is obvious that the plaintiff, being a consul general of the defendant, is not covered by the inviolability provisions afforded to diplomatic agents under international law. Above all, it is the sending state which grants the status of consul to individuals in accordance with Article 10 of the Convention on Consular Relations, which provides that heads of consular posts are appointed by the sending state, looks like they misspelled state, and admitted to exercise their functions by receiving state. If the defendant contests the status of the plaintiff as a consul, he cannot lay claim to it. So there you go right there. I mean, right, if they did not, what is the word I'm looking for here, delegate the power of consul to Dr. Malachi Z. York, then there's no claim. You know, the claim doesn't exist because according to their government, they never issued it, which, you know, it is what it is. Furthermore, assuming the status of the plaintiff as consul was established, which in our opinion is not the case, an arrest and detention is possible by virtue of the provision of Article 43 of the Convention on Consular Relations, which permits immunity only in connection with one's consular functions as consul, which is not the case with regards to the charges against the plaintiff in this instant case. But the charges were for sexual offenses and racketeering, and we consider these offenses grave crimes covered by Article 41 of the Convention on Consular Relations. With regard to issue number 3, whether there has been a violation of the human rights of the plaintiff as provided for by international rights instruments to which the defendant is a party. As earlier noted, the plaintiff's claims is based on the alleged failure of the defendant to honor its obligation towards him under the Vienna Convention on Consular Relations by her failure to stop the arrest, prosecution, conviction, and incarceration of the plaintiff, as well as failure to secure his release thereafter. His contention is that, being a consul general of the defendant, he is immune from criminal prosecution by the host state by virtue of his diplomatic status. In the same vein, he has alleged that the defendant's failure to intervene and stop his prosecution and conviction and secure his release from prison is a violation of his rights under Articles 2 to 7 of the African Charter on Human and People's Rights. His contention is predicated on the alleged inaction of the defendant to call to play in his favor the relevant provisions of the 1963 Vienna Convention on Consular Relations to secure his release. The question to be asked, in practical terms, is whether there is a legal obligation on the defendant to intervene on behalf of the plaintiff to secure his release. We have already stated above that the 1963 Convention on Consular Relations, which guides the operation on consular officials, grants very limited privileges and immunities, in that it limits their inviolability to acts done in performance of their consular duties. Accordingly, since the protection accorded consular officials is not absolute but limited to acts and performance of their official functions, is the defendant in a position to claim on behalf of the plaintiff immunity from prosecution in the circumstances of this case? In other words, is the defendant under an obligation to take diplomatic or other measures to secure the release of the plaintiff from prison and repatriate him to the defendant state? The answer is simply in the negative. First, because the offense for which the plaintiff was charged, prosecuted, and convicted has nothing to do with his employment as Consular General of the defendant. In committing those acts, he was on a frolic of his own. Let's look up this word frolic. What does frolic mean? What does frolic mean? Let's try to understand what the judge is saying here. He said he was on a frolic of his own. Play and move about cheerfully, excitedly, or energetically. So he was basically messing around in America, right? So I don't know if that was the case, but unfortunately, this is how the judge is looking at it. We had already noted that the basis underlying the grant of diplomatic immunity under customary law and treaties is to ensure the doctrine of sovereign equality of states and allows representatives of foreign states to carry out their functions in the receiving states without hindrance, usually referred to as the doctrine of functional necessity. It is not meant to benefit individuals directly, but rather a right apportionate to their state. A right apportionate to their state. What does that mean, apportionate? I've seen the word before, but can't remember what the meaning was. So let's see. Belonging, pertinent. Secondary buildings that are pertinent to the main building. Maybe it means a part of the whole. Something like that. So it is not meant to benefit individuals directly, but rather a right pertinent to their state. Oh, so what he's saying is the consul general has a right, but it came from the state. It was delegated to the state, meaning it was a power of the state to give to the consular. It's not the consular's right by himself. That has to be granted to him by the state, which would be Liberia. Okay, so getting toward the end here. Accordingly, the state declares that the defendant has no legal duty to secure the release of the plaintiff from prison in the United States of America. This naturally leads us to the determination of issue number 3. It est, whether taking into consideration the facts and circumstances of the case, any known human rights of the plaintiff has been violated. Article 9(4) of the Supplementary Protocol of this Court, 2005, creates the human rights jurisdiction of this Court and allows it to determine cases of human rights violations that occur in any member state. For a claim for violation of human rights to be sustained, the suit in question must be predicted on a claim for human rights recognized by international human rights instrument to which the member state is a party. Such right must have been violated by an act of the defendant member state within its territory and other conditions for sizing the court with competence must have been satisfied. And I already know where this is going. You can already tell where this is going. Check it out. For the fact that they're saying that for a claim of human rights to be sustained, basically the international human rights instrument, the human right violator would also have been a member state, right? And this goes back to what the defendant was saying, that the United States is not a member of the ECOWAS territorial agreement consent that the member states decided to be a party of, or the agreement of the Western African states. The United States is not a Western African state, so they can't rule against the United States because the United States never gave them jurisdiction to rule over them because they're not part of this agreement. So, okay, let's keep going. Applying the above elementary criteria to privileges and immunities granted to consular officers, which the plaintiff claimed to be one. Do they have the character of human rights? The answer is in the negative. They are not recognized by any known human rights instruments, both locally and internationally. Their claims as one of the rights envisaged by Articles 2, 3, 4, 5, 6, and 7 of the African Charter on Human and People's Rights, in particular on any other international human rights instrument in general, cannot be sustained. In the circumstances, the plaintiff's case has not disclosed any characteristic violation of his human rights to ground the court jurisdiction to entertain the same. In Alhaji Amani Tijani versus Federal Republic of Nigeria in 4 ORS 2004-2009 CCJ-LR, the plaintiff alleged a breach of his right to freedom from arbitrary arrest and detention provided for under Article 6 of the African Charter on Human and People's Rights. This court copiously laid down general conditions for the exercise of its human rights mandate. Thus, the combined effect of Article 9.4 of the Protocol of the Court as amended, Article 4G of the revised treaty, and Article 6 of the African Charter on Human and People's Rights is that the plaintiff must invoke the court's jurisdiction by 1. Establishing that there is a right recognized by Article 6 of the African Charter on Human and People's Rights, that this right has been violated by the defendant, that there is no action pending before another international court in respect of the alleged breach of his right, and 4, that there was no previously laid down law that led to the alleged breach of abuse of his rights and freedom from arbitrary arrest. All right. Similarly, in Musaleo Keita versus the Republic of Mali, 2004, this court also refused to assume jurisdiction where the applicant did not identify the exact violation alleged or specified the particular right allegedly violated. Applying the principles established in above cases, this court is of the view that the plaintiff in the instant case has not identified the specific right violated by the defendant in relation to him. He has purported to state that his rights under Article 2, 3, 4, 5, 6, and 7 of the African Charter on People's and Human Rights have been violated by the defendant, but the right to diplomatic and consular protection is not one of the human rights recognized by the articles. Hold on real quick. All right. By those articles. In this regard, the entire action of the plaintiff is incompetent, must fail, and is hereby dismissed. So that's kind of disappointing, man. I mean, the Liberian government, had a pretty good defense, and they just couldn't crack it at all. So, for these reasons, adjudicating in a public session after hearing both parties in the first and last resort, the court, in terms of merits, in regard to this application, holds that the defendant has committed no human rights violation against the plaintiff and that the plaintiff's claims is hereby dismissed. As to the cost, ask each party to bear its cost, and the following hereby append their signatures. There's the judges, there's the registrar, and that's basically it, man. So unfortunately, Dr. Malachi Z. York is not getting the proper representation. And another thing I wanted to point out was this was recorded on April 18th, 2016. And I wanted to point out, if we go to YouTube, and that's April 18th, right? Let's check one more time. A sanity check. Okay, yeah, April 18th. And if I go to YouTube, let's see. I'm gonna type in Dr. York case. Yeah, here we go. That's York's case. No, I think I want to type in his lawyer's name. That's a Victoria's Secret. No, not that Vicky. And Clemency. 2-9. I'm trying to match up these dates here. Oh, she had a radio interview. I didn't even hear about that. So she's been Dr. Malachi's lawyer for a long time, since 2014. How about we just type in? Let's go to her channel. With Mario Giuseppe. Message to President. The pardon. Yeah, we got the pardon. Okay, what I wanted to get to was I'm trying to. Together we can do anything. It's about 2 years ago, so I'm trying to find something from 2 years ago. It might be this one. Let's check this out.
Hello, it's Victoria Broussard, and I wanted to express a couple of things to you guys. I know that it's been quite a while since we provided an update. As you know, the end of last year was very busy with organizing the ball as well as the clemency vigil. And so things just, time just was not there for it to get done. And we also did have a visit with Doc right before the ball. However, it's difficult at this point to continue with the updates the way that we were doing them before. So basically, I'm just going to give you the legal update from this point forward, and that's going to be all that we'll be able to bring to you from this point on. So I appreciate everyone sending emails and requesting updates and all of that, and I've tried to email as many people back and Facebook back, but this is the best way to get the most amount of information to you all at once. So let's start with the clemency. It goes without saying, I think, that I am very disappointed that, Obama did not grant the clemency.
But wait a minute, the funny thing is, I'm gonna end this right now, but the funny thing is they never mentioned the ECOWAS case. If you're gonna give an update, give a true update. there's no mention of it. There's a mention of clemency, which they had to file because Obama was done. This is just when Trump became president. So they tried to do a clemency with what is that? With Obama and now Trump, as of December 21st, 2018. And then the ECOWAS case didn't work because the argument was so bad. And then, there was fraud involved and all that stuff. So that doesn't look good for Dr. York on clemency either, because the United States may pull up that ECOWAS case and be like, oh, look, the guy's trying to pull fraud. So I don't know. I'm frustrated by the whole thing. So I'm gonna go ahead and end the video. Thanks for the couple of folks that are tuning in. Hopefully this long drawn out case that I had to read was informative to those who are in tune and focus on the master teacher situation. And maybe Victoria Broussard needs maybe she needs help, from the public at large. Maybe how to frame arguments. Somebody should definitely look over some of the legal arguments that she's making for Dr. Malachi Z. York. And this is just constructive criticism. I don't want to disrespect anyone as the vice president of United Nuwaubian Nation of Moors, but we've had some pretty bad press from her and the UNN and Mario, her boyfriend, who actually tried to challenge the chief White Buffalo. So I'll keep it constructive as far as giving suggestions to Victoria Broussard as to how to move forward and how to frame an argument, because the arguments are being shot down because they're not framed well, then they're not strategized well. So anyway, Wadu, I'm glad for the folks that are tuning in live. We appreciate that. And always remember, Abdul Kul Tafalatat Wa Bazum Bi Samus El Kaluam. Wadu.